it's not sufficient to say that someone has committed forgery just simply because you have identified two different documents that are meant to be saying the same thing. If you follow this from the human rights perspective, there's one thing called Article number 6. It says that every individual is presumed innocent until found guilty by a court of competent jurisdiction. So, for example, you go to a university and that university provides a document saying, oh, this is the real document. And then the client or the candidate provides another document which is different from that. And then you arrive at a conclusion that the candidate has forged a document. Now, that is only a first step. In order to prove that, you're going to have to go to court. Someone has to go to court and get a court to deal, to make a pronouncement, which we call a declaration. A declaration will be a remedy that will be given by the court to say, and it is a simple declaration, but there has to be a trial, a hearing or a trial, where the documents and evidence will be heard by the judge, and then the judge will make a decision that this document was forged. Now, that is here now going via the civil justice procedure. And then there's another route, which is the criminal justice procedure. The criminal justice procedure is that you get the police involved, and the police get the person arrested, and the person gets arraigned and found guilty in a criminal court. And then in that case, it has now been confirmed that that person has been convicted of forgery or fraud on the criminal justice part of things. On the civil justice part of things, then the person has to get a judgment that the person has actually forged a document. And then it is this evidence that you now need to try and get the person out of government. Because don't forget that one is presumed innocent until they are found guilty. Without this type of document, it will be very, very difficult to prove to the court that the person does not meet the criteria to become president. Now, there is another point that I also need to talk about here, which is the question of civil and aspect of this process. So when you come to the civil justice procedure, in terms of the president having provided or having been alleged to have provided a forged document, this is a question about the INEC decision. So INEC's decision was supposed to take into account whatever document that was in front or petition that was in front of the decision maker as to the validity of the documents or statements made by the candidate. When INEC now approves this candidate, INEC has made a decision. And that decision is only INEC that is approved by law to make that decision, and court cannot interfere unless in certain strict circumstances. And if that is the case, what will now happen is that anyone that is agreed by INEC's decision will have to go to court. The court to deal with that, obviously, the reason why I haven't said this a long time ago is because it is considered that Nigeria has its own procedural law, and that Nigerians are experts on their own legal procedures. But it turns out now to me that Nigerian legal procedure is not quite different from the UK one. To challenge the INEC decision before the election, the place to go to should be, in this country, will be a high court or a court that has the jurisdiction to deal with questions about the decisions made by public authorities. And if that was supposed to have happened before the election, which was possibly last year, or before the election this year, and it did not happen, and now someone is taking that question to the Supreme Court, obviously there will be a problem, because one of the obstacles, which is the main hurdle, will be that the time has passed, because all of these things have time limits. In this country, they have 3 months time limit to challenge a decision that has been made by a government body or public authority. So what actually might happen, which I anticipate that has happened in this case, is that INEC decision to allow Tinubu to remain to contest the election should have been challenged at the High Court, and that should normally have taken place before the election. And if that hasn't taken place before the election, and suddenly a lawyer realizes that, I should bring this, that shouldn't be dealt with at the election tribunal, because the election tribunal might not have jurisdiction to deal with that. And then now you have now raised, if you now raise a question to the Supreme Court to deal with that, obviously you're going to be met with a time limit decision by saying that, are we not going to look at the merits of your case because it's now time barred? So all of these are legal frameworks that everyone, obviously these are some of the technical things that most lawyers should be aware of, because it can be frustrating to clients that their case has not been heard, and it's not very good for the law and people, and the way people view the law when it is that someone has made a mistake or failed to understand the procedure that they were meant to follow. And obviously, as I said before, I haven't got the time to read the documents or to understand what is going on, or to even listen to the Supreme Court judgment today. I'm not going to do that, but I have an idea of what it is, that someone is raising a matter of forgery against an incumbent president, and that matter has been taken to the Supreme Court, and then the Supreme Court has ruled on it. And then obviously what strikes to my mind is why Supreme Court, and why now, why was it not dealt with before the election? And these are some of the basics. And then once you get it, if you know the facts, then you can fit them into what I've just said, and then you will even understand it better than I do. Thank you very much.